Okay, good morning once again to everyone, and welcome to this morning's employment law seminar. My name is Marty. I am a partner at Devry Smith Frank, and once again, thank you all for joining us today. Today's seminar will go until about 11 o'clock. And we have a great program for you today. We'll be covering 5 very current topics in employment law. And I will be joined today by 3 of my colleagues, which is very exciting. The last few seminars, that has just been me. So I'm excited to be joined by a few of my colleagues today. The program will be accredited for 2 CPD hours, both for lawyers and for human resources professionals. So for lawyers, I'm told that you can go right ahead after the seminar and claim your hours. And for human resources professionals, I am told that the HRPA code will be sent to you by email tomorrow. So you can watch for that in your inbox. Our firm has a newsletter that gets published from time to time, typically about monthly. And we also have a mailing list as well that will keep you informed of our events, such as this employment seminar series. So if you don't already get those emails from us and you would like to, feel free to get in touch with us and we'd be happy to add you to the list. So for today, we talked a little bit about already how we have accreditation for this program. So again, 2 hours of CPD for both lawyers and human resources professionals. And the slides will be available after the presentation. If you'd like a copy of the slides, you can either email any of the presenters, or the slides will also be available on the DSF website. So here is the schedule for today. Very shortly, I will start with the first topic here, which is a COVID-19 case law update with a focus on vaccination policies, employee terminations, and terminated employees' eligibility for employment insurance. My colleague, Tim Gindy, will then speak to you about the classification of gig economy workers. And in particular, he will address the worker classification issues as among employees, dependent contractors, and independent contractors. My colleague, Nathanial, will then speak to you from a tax law perspective about what to expect in a CRA audit. We will then take a break for about 15 minutes. We'll move forward with the Working for Workers Act, which will be discussed by my colleague, Nicholas Reinkluers. And then I will come back and talk about the final topic here about whether an employee's level of sophistication is relevant in determining the enforceability of a termination clause. There will then be a Q&A period, and then we will wrap up. Now, on the topic of questions and answers, you should all have access to the Q&A tab in the Zoom webinar app. If you have any questions for any of the speakers throughout the presentation, feel free to type your questions into the Q&A box, and either one of the panelists will answer your question in writing, we'll type the answer throughout the seminar, or we'll answer the question live during the Q&A period. So without further ado, we are going to move right into the presentation topics here, and we will get right into the topic about vaccination policies, employee terminations, and the eligibility for employment insurance. And there's my contact information. Okay, so quick background here about vaccination policies. Vaccines against COVID-19 do provide protection against disease, in particular against severe outcomes. The vaccines that have been authorized for use in Canada have been proven to be safe and effective. There have been some myths and misinformation that have been abounding. I'm not going to get into them today, but they have essentially been debunked. Now, employers also have a statutory duty to protect the health and safety of employees, and this duty is set out in the Occupational Health and Safety Act. So employers should look at mandating vaccination as one way to meet this duty. And I say one way because it should also be combined with other public health precautions. So things like we're talking about hand washing and physical distancing and masking and so on. And when determining the nature of a vaccination policy, it's important for employers to consider the specific and unique challenges that their workplace faces. So in other words, and we'll get to this later, this is not a situation where a one-size-fits-all policy is generally going to work. So employers can become exposed to legal liability in a number of situations. So the first is if they don't take reasonable steps to prevent COVID-19 infections in the workplace. And we're talking in particular if an employee develops a severe outcome or dies and can show that they contracted COVID because the employer did not take reasonable steps to protect them. Employers could be liable if they don't accommodate employees under the Human Rights Code. So we're talking about medical and religious possible exemptions here, although they are rare, they do exist. And finally, employers can get into trouble if they do not take proper steps to safeguard employees' personal obligation or personal health information rather. So we're talking about things like their vaccination status or a copy of their vaccination receipt. Health Canada and NACI are very pro-vaccination, and in fact, the courts have taken judicial notice that medical authorities recommend vaccination. There's a couple of cases there which are cited here on the slide. Now, there are some people who will not be able to be vaccinated or would be entitled to exemptions under the Human Rights Code. So again, religion or disability, and others continue to remain unvaccinated for personal reasons. Dr. Davila, back in August of 2021, made this statement that is very pro-vaccination and encouraged employers to have workplace vaccination policies in the interest of health and safety. And the courts have also found that medical officers, such as Dr. Davila, should be afforded what they've called significant deference here. So when we're dealing with vaccination policies in the workplace, so we're talking about policies that require employees to get vaccinated, basically you're balancing the interests of health and safety on behalf of the employer, that those obligations have to be met, with an employee's human rights and other interests. And if an employer policy unreasonably infringes upon the rights of employees, the policy may not be enforceable at the end of the day. And if an employee is terminated based on a breach of that policy, then the employer may end up being liable for severance. Now, when we're talking about terminations, the courts will eventually be asked to draw the line in terms of what's reasonable and what's not, and what terminations for cause should be upheld and which ones should not. However, we do have the benefit of a number of labor arbitration decisions, which do provide us with some insights as to how the courts might rule. So we know that arbitral awards are highly contextualized, so really it's the facts and circumstances that matter. And we're talking about factors like the nature of the business, the type of workplace, the kinds of services offered, the characteristics of the employees, and other specific dangers or hazards and how they might interfere with the employer's business. And these things will change as the pandemic continues to change. So in order for the policy to be enforceable, Basically, it needs to be reasonable. It has to strike an appropriate balance between both the employer's interests and the employee's interests. And it should be custom tailored to suit the parameters and realities of the workplace. So in other words, it's not necessarily going to be a policy in which one size fits all. So let's look at some of the decisions that have come out in the labor world. And there are 4 types of COVID-19 workplace policies that have been considered. So we've grouped the cases here for this presentation into 4 categories. So testing, restrictions, vaccination, and disclosing vaccination status. So on the subject of testing, testing of employees is going to be found to be generally reasonable. So in this first decision called Crescent Care Nursing, Retirement Homes, and Christian Labor Association, the arbitrator found that a requirement that employees be tested every 2 weeks for COVID-19 was reasonable. And this was because the risk of controlling an infection in a place where the elderly were outweighed the minimal intrusion of a test. In the decision below, in Unilever Canada, a food manufacturing facilities policy requiring all employees be tested every week was found to be reasonable. And the arbitrator concluded that this was the case because it was prudent to exercise caution in a facility that was subject to food safety regulations. In the next case here with the Ellis Dawn Construction, this was a case where the employer required everyone to be tested twice per week to enter the work site, also found to be enforceable. It was an essential service and workers routinely moved between job sites and employers. So this requirement was found to be reasonable. And then in OPG and the Power Workers Union below, again, testing unvaccinated employees every 2 weeks was found to be reasonable. So regular testing is going to be reasonable. Let's look now at restrictions. So in the decision of OPG and the Power Workers Union, the arbitrator found here that restrictions are generally reasonable. So even where physical fitness is a required aspect of the employee's position, that restricting access to the employer's gyms and fitness facilities only to vaccinated employees was reasonable. And this was because the arbitrator found that gyms were high-risk areas for transmission, and that vaccination is required for the same reason that Ontario requires patrons of public gyms to be vaccinated. Vaccination will depend on the circumstances in terms of whether or not the policy will be reasonable. So we've talked a little bit about the Human Rights Code exemptions. The Human Rights Commission, which comes out with policies which interpret essentially what the Human Rights Tribunal is doing and comes out with opinions as to essentially how human rights laws should be applied, commented that a person who chooses not to be vaccinated based on personal preference does not have the right to accommodation under the code. So mandating vaccination is likely to be reasonable where the risks are high and vulnerable populations require protection. It's likely reasonable when necessary to comply with an existing contractual relationship, such as an employment agreement, collective agreement, or lease. And in contrast, though, mandating vaccination may be unreasonable where practical alternatives exist, such as working remotely, working outside only, and physical distancing, masking, screening, and testing, the usual sorts of things. In the decision here of Electrical Safety Authority and Power Workers Union, an employer requiring all employees to be fully vaccinated or subject to discipline was found to be unreasonable in this case. And this was because the vast majority of employee work, according to the arbitrator, could effectively be conducted remotely. And that was an acceptable alternative to having majority of workers come back in person. Now, a couple of notes here that the arbitrator was careful to specify that the decision should not be seen as vindication for those who chose to remain unvaccinated. And the decision also acknowledged that there could be circumstances when requiring all employees to be fully vaccinated would be reasonable. In the cases here at Bunge, Hamilton, Canada, a vaccination policy for an agricultural supplier was found to be reasonable. And this was the case because the policy was necessary to prevent material interference with business and to comply with the terms of its lease from a federal port authority. And then in UFCW and Paragon, the mandatory vaccination policy was upheld on the facts of this case. So first of all, the security company's clients, many of them required the security guards to be vaccinated. So it was necessary to comply with those contracts. And also there happened to be an article in the collective agreement which mandated employees to agree to vaccinations if they were required to attend at a particular job site, which was a pretty important fact in this decision. In Power Workers and Lexicon, the employer required all employees to be fully vaccinated or to attend an educational program. And if they didn't, they'd be placed on unpaid leave. The policy was found to be reasonable as it applied to most employees, but it was found to be unreasonable for employees who worked exclusively from home or exclusively outdoors. So that's where the arbitrator decided to draw the line in terms of reasonableness in this case. Disclosing vaccination status, or a requirement for employees to disclose their vaccination status, is likely to be reasonable as long as the employer takes appropriate steps to maintain the confidentiality of the information. And there's two cases which address that issue. This is a case about an employee who worked at Scotiabank Arena for not disclosing his vaccination status, and the employee lost. The policy was found to be reasonable as well in this case. The purpose of a policy may affect its enforceability. There are a number of possible purposes that an employer can have when enacting their policy. So it could be things like improving health and safety, promoting vaccine safety education, improving attendance, or stopping the spread of COVID-19. Now, in light of the Omicron wave, an argument, I suppose, could be made that the policy would be unreasonable if the policy's purpose was to reduce the spread of COVID-19, because the variant is far more transmissible, and it's not so clear what having two vaccines will necessarily do. Now, it's expected that vaccines are nevertheless going to be effective in preventing severe outcomes. But I do want to take a look at something that the arbitrator in a Lexicon and Power Workers Union said in dealing with an argument about Omicron. So basically, the union said that the policy shouldn't be reasonable because of Omicron. It's just, no point. There's no clear objective. But the arbitrator essentially said no and said, look, the employer doesn't have to establish with scientific certainty that there's going to be a cause and effect relationship, because we still don't know a lot for sure about this. The entire point is to take precautions as against the yet unknown. And so despite the argument about Omicron, the arbitrator still found a mandatory vaccination policy to be reasonable. Terminations for violating COVID-19 policies. So these are cases, employee was terminated in Garda for not self-isolating pending the result of a COVID-19 test. The employee was terminated, and the arbitrator found it reasonable. And an employee here who was terminated in response to providing false answers to COVID-19 screening was also terminated, and the arbitrator found it to be reasonable as well, and that's the LIUNA decision. And suspension, this employee in Ryam Inc. Forest was suspended for threatening to give his supervisor COVID by removing his face mask and pretending to spit in his direction, and a 2-month suspension was ultimately found to be reasonable. Before I end, I just want to comment quickly on what Service Canada is doing about employee eligibility for EI if an employee is terminated as a result of failure to comply with the employer's vaccination policy. So really the key here is, if that happens, if you're terminating someone for violating a COVID-19 policy, you would use code M on the record of employment, but then Service Canada is likely to contact you as an employer to determine whether the policy was clearly communicated, whether the employees were informed that termination was a possible penalty for non-compliance, if the application of the policy to the employee was reasonable, which is the big one. That's what we've spent the last 15 minutes or so talking about, and then whether or not there were any applicable exemptions, which is really a reference to the Human Rights Code type exemptions. So these are important factors to consider when drafting a vaccination policy. We have written a blog which addresses all of the issues and goes into a bit more detail about some of them. This is the title of the blog here. It should already be published in our firm's blog on our webpage, and if not already, should be available through the firm's social media as well. So I would encourage you to read it. So that concludes the presentation on this topic. And I am now going to pass the floor over to my colleague, Tim Gindy, who will speak about worker classification. Tim, it's all you.
Thanks, Marty.
I'm just going to stop. Let me just stop my share, Tim, and then all you.
Excellent. Worked well. Good morning, everyone. Thanks for coming to our seminar today. And as Marty mentioned, my name is Timothy Gindy. I'm going to be speaking about the classification of gig economy workers, which has been a popular topic, but has been really, still under development in a lot of ways. So I'm going to be talking about the distinction between an employee, a dependent contractor, and an independent contractor. And these are effectively the three types of workers or classification of workers that you can have under the current state of the law. So an employee obviously is the traditional relationship that we all know and are accustomed to. You'll see a paycheck being given to an employee with taxes being remitted by the employer to the CRA. Nathanial is going to go into a lot more detail about that. The Employment Standards Act governs the relationship between an employee and an employee and an employer. You have certain entitlements under the Employment Standards Act, which are mandatory, that the employer cannot contract out of, cannot get out of in any form or fashion. Things like vacation pay, statutory holiday pay. If someone's terminated, there's a minimum amount of pay in lieu of notice that is required to be paid to the employee, assuming, of course, that the termination is not for willful misconduct, disobedience, or willful neglect that is not trivial and has not been condoned by the employer. An employer may be required to pay a further amount of pay in lieu of notice based on the common law. So if there is, for example, no contract in place, there is a minimum amount that the Employment Standards Act mandates that an employer must pay, but an employer may be liable for further damages based on the common law. Some employers, depending on the number of employees and their payroll, may be required to pay severance pay as well as pay in lieu of notice. And obviously, this is not an exhaustive list. The Employment Standards Act has a lot of requirements. In contrast to employees, independent contractors have a different relationship with those who pay them or those who engage them. So an independent contractor will normally submit an invoice to the entity engaging them and are generally required to remit their own taxes to the CRA. So they'll submit an invoice with HST, and then they will normally remit their HST and pay their corporate taxes themselves rather than the employer doing it for them. They do not have an entitlement to vacation pay or statutory holiday pay, and that kind of ties into number 3 because they're not covered by the Employment Standards Act, and so they're therefore generally not entitled to the protections that the ESA provides. There's no obligatory pay in lieu of notice on termination unless you have a contract that provides otherwise. And then you have this third category, which sort of falls between an independent contractor and an employee, and they're called dependent contractors. And the law with respect to dependent contractors is really still developing. If someone is found to be a dependent contractor, there will undoubtedly be features of an independent contractor relationship. An example could be that they're being paid through an invoice where they also put HST on that invoice, and then the worker has to remit the HST. But a unique feature of the dependent contractor relationship is that the worker works exclusively or nearly exclusively from one entity, which means that they derive substantially more than 50% of their work from the one entity. And that number comes from the Court of Appeal. In that particular case that I cited there, it was a lawyer who was claiming that their client, they were a dependent contractor based on the relationship with their client. The Court of Appeal said, it's not really there because you're not past that 50% threshold, or at least substantially more than that 50% threshold. And so the court declined to find a dependent contractor status there. But like employees, dependent contractors are entitled to some reasonable common law notice. So it's not the same as an independent contractor relationship in that a dependent contractor will still be entitled to some notice when they are terminated. So we've got the 3 classes of workers, but how do we determine which one applies? So this can be a complicated process. It involves reviewing the facts of each case carefully, and every case that differentiates between the classes of employees will depend highly on the facts. So we're going to go through the analysis. So the first step is that you have an employee or a contractor. That's the 2 possibilities in the first stage of the analysis. So whether a person is an employee or a contractor is going to depend on several factors. So the 7 factors are the extent to which the activities of the worker were controlled by the other contracting party, whether the worker provided his or her own tools or equipment. And certainly you can imagine for something like IT, it's going to be a lot different than, for example, a carpenter who has, perhaps hammers, nails, and woodworking material or woodworking equipment. Third is whether the worker hired his or her own helpers. Fourth, the extent to which the worker assumed financial risk. 5, the extent to which the worker had invested capital in the enterprise. 6, the extent to which the worker had management responsibilities. And last, whether the worker had an opportunity for profit in the performance of his or her tasks. Ultimately, the Court of Appeal has said that at the heart of the matter is whose business is being operated. And Justice Galiz really says that is the crux of the question. Yes, we have all of these factors, and in different cases, you're going to have different factors that apply, some that don't, or you'll have cases where some factors are heavily in favor of one side versus another. It really depends on the facts and circumstances, but the question of whose business is it is really at the heart of the matter. And they've said, and courts have said, that this is not an exhaustive test and it's not the only necessary test. And the other factor is what the parties may choose to call the relationship is relevant but not determinative. The court will determine the nature of the relationship based on the conduct of the parties. And so it's important to understand that you might agree to a particular type of arrangement. You might agree to being called a particular class of worker, but that does not necessarily mean that you're going to be classified that way by a court. Now, if the worker is found to be an employee, then you're done the analysis. They're an employee, they're entitled to Employment Standards Act benefits and all the things that come along with that. But if the court determines that someone is a contractor, then you've got to go one step further. Are they dependent or independent? And the court's going to look to three factors to determine whether a worker is dependent or independent. First, the extent to which the worker was economically dependent on the particular working relationship, and that's exactly what it sounds like. Is that person deriving really all of their income from the one source? It doesn't necessarily have to be all, keeping that in mind, but you just have to show an economic dependency. Second is the permanency of the working relationship. So are we talking about a situation where they work for someone for 3 months, or are we talking about 13 years, for instance? Third is the exclusivity or high level of exclusivity of the worker's relationship with the enterprise. And so the full relationship is going to be important here. And the courts are going to go through the entire relationship. It really doesn't matter how long it is, in the sense that the court will want to know the entirety of the relationship to make the determination of whether or not there is exclusivity, or at least a high level of exclusivity. So the more permanent and exclusive the contractor relationship, then the less it resembles an independent contractor status, and the more it will resemble an employee relationship, and therefore the relationship should be classified as a dependent contractor. Now, why does it matter? Well, there's a number of reasons why it matters. First, the tax consequences are going to be significantly different. Getting it wrong could create a situation where the CRA is going to look to back pay for failure to withhold the appropriate amount of taxes from an employer. So for employers, you're certainly going to be concerned about how you're classifying your worker. Certainly, the Employment Standards Act, Section 5.1, requires employers to classify employees or otherwise correctly, right? And since the employer has the obligation of withholding the taxes, it could become a huge landmine if they don't do it properly, if they don't classify properly. Beyond that, standard employment benefits are not generally paid in an independent contractor relationship. The back pay for these benefits can be significant, though. So if you've said, okay, well, you're an independent contractor and I'm going to call you an independent contractor and you're going to agree to be an independent contractor, but then a court comes along and says, hold on a second, this person's an employee. Well, there could be a huge liability there for having to pay statutory benefits such as vacation pay or public holiday pay. And there's obviously going to be a limitation argument on those types of benefits, but it's quite possible that the court will look at the characterization and say, well, since you've misclassified them, the limitation period is pushed. There's certainly a few class actions ongoing about that very issue as we speak. So what do you do if you're unsure? Well, you've got to contact a lawyer, I think. That's probably your most important step. Go through the facts. An employment lawyer is going to have to know what exactly the relationship is comprised of. How are you paying them? How are you treating them? What are your expectations? How much control do you exert over them, right? And from an employee's perspective or a worker's perspective, same questions to see if you have been classified correctly. Usually these problems will come up on termination. Now, I mentioned that the law is not particularly developed in respect to dependent contractors as it is with independent contractors and employees. And in the Court of Appeals decision of McKean reads, the Court of Appeal made the following statement at paragraph 22 of the decision. So it says, RHH submits that the law provides for an intermediate position of dependent contractor. RHH is the defendant, by the way, between employee status and independent contractor status. I agree. The case law's evolution demonstrates the existence of an intermediate category defined by economic dependency in the working relationship, requiring, inter alia, or among other things, some reasonable notice for termination. So the reason I highlighted inter alia, among other things, is that there is a potential that dependent contractors may be entitled to more than just reasonable notice. Now, there is no case that has come out and specifically said that, but I would submit to all of you that the fact that the Court of Appeal used that wording of among other things means that they're contemplating a scenario where there could be other things that a dependent contractor may be entitled to. Certainly, their contract will be a factor, but I'm thinking even perhaps beyond that. So where are we going? Where are things going? Well, we know about the Uber case. The Uber case currently in Canada, at least, has basically the big finding has been that the arbitration clause, which required arbitration in the Netherlands, was unconscionable. And so the Supreme Court has struck it down, and the case is ongoing in Canada. In the UK, the Uber drivers were classified as workers. This was a classification between an employee and an independent contractor, sort of like a dependent contractor. In California, Uber drivers were classified as employees, and then there was a proposition that came out to exempt Uber drivers from being classified as employees, and it was successful in California. They kept the Uber drivers as independent contractors as a result. However, a judge at a lower court in California struck down the proposition itself as unconstitutional. And then that ruling was upheld on appeal. So it's probably, because it's a constitutional matter, going to go to the US Supreme Court. And, the question is, will that proposition be found to be unconstitutional? Who knows? And I'll end off, before I turn it off to Nathanial, with, what's going to happen in Canada in terms of the Uber drivers. I suspect, but I can't say with any certainty, that they're probably going to be defined as dependent contractors if they have the factors that we've talked about near exclusivity and a permanency to the relationship. But I think it's going to be on an individual basis, right? So that if someone is working exclusively or near exclusively for Uber versus someone who is working maybe 10% of the time for Uber, it's going to be a bit of a different scenario. Now, with that said, I'm going to turn it over to Nathanial to talk about all the tax consequences that could come along with that. And take it away, Nathanial.
Thank you, Tim. Good morning, everybody. Pardon me. You might be wondering why a tax lawyer is joining you this morning. I was asked to provide some legal analysis as well as some personal experience related to what to expect in a CRA audit on this very issue, meaning independent contractor versus employee. Hope you can see my beautiful bald face there. So title would be what to expect in a CRA audit, as you know. So we'll start. So the Income Tax Act, strangely enough, for such a technical statute, doesn't actually contain a precise definition of what an employee is. There is a definition, and it merely operates to state that the concept or an employee includes an officer. So that means a director or CEO, et cetera. So in Canada, under the Income Tax Act, that's developed basically through the common law. Timothy already went through a lot of that. I'm going to go through some of the cases. There's a bit of overlap in terms of what CRA and what the Tax Court of Canada, the cases they tend to rely on. The determination is a question of fact. No one factor on its own is determinative, but we have to look holistically at the relationship. And central distinction, I've heard it said, is that we're looking to determine whether the relationship is one of a contract of service versus a contract for service. So again, Timothy already went through a lot of the law, but just a bit of reiteration here. The two leading cases from the CRA and the tax court's perspective that get applied the most are the Weavy-Dore and the Sagaz Industry case. Weavy-Dore was a case related to the independent contractors would install overhead garage doors, et cetera. And at first instance, the Tax Court of Canada held that because the contractors were such an integral part of the business that they must have been employees. And the Federal Court of Appeal came around and said, you've made a mistake there, Tax Court, because what we want to be doing is to examine all of the factors. Those factors were broken down much more succinctly by Tim than I could do. But in Sagaz, that was control, chance of profit versus risk of loss, integration, and then who owns the tools and the equipment. As Tim said, in the civil context, Sagaz sort of seems a bit vestigial. It's been largely supplanted, but CRA and the tax court tend to rely on it heavily because it is a Supreme Court case still. There's been a bit of a development in the law more recently, as in the last decade, where in the Federal Court of Appeal, Justice Mainville created sort of a first step in the analysis. What we do there is we look to the written agreement and then we examine the objective reality of the relationship. I don't really think that that's adding anything substantive. It's just more formalistic than anything. It's not really, doesn't add anything substantive to the cases that we're already using. One thing to note, and I think Timothy also touched briefly on this, was in tax law, one of the main sort of principles is that form matters, right? So the way that the parties choose to arrange their affairs generally is going to be what's determinative. The employee versus independent contractor distinction is actually quite rare in a tax context. That having been said, there is support from the Federal Court of Appeal that would allow us to draw the conclusion that where an employee is operating through a corporation that's validly been incorporated and has not yet been dissolved or wound up, that the CRA will not be able to allege that an employment relationship exists. As an aside to that, there's a concept called the personal services business that taxpayers ought to be aware of, because that can result in very deleterious tax consequences. If you want more information on this, you really need to speak to a tax lawyer. But in some employee, independent contractor, question of fact, it's determined separately from any other statute. So what the OLRB or what the Ontario Superior Court might rule on this is not determinative, although it's very persuasive, let's say. So Tim also mentioned about payroll withholdings, and that's sort of what I want to get into here is, why does CRA even care? Like, from a conceptual perspective, a dollar is a dollar is a dollar. Income is income, taxes paid. You file your tax return, you pay your taxes, or you get your refund every year. The real concern here is the protection of the tax base. So in Canada, the payroll withholding system is designed to make compliance and payment of tax as painless, let's say, or at least as easy as possible for the vast majority of Canadians. I don't know the actual statistic, but I would say it's probably fair to assume that at least 90% of people have their income taxes withheld at source. And as a part of that, what the Income Tax Act and the other related acts do is they create an obligation on the employer to ensure that these taxes are withheld. If they're not withheld, or if they're not paid to CRA, it's the employer who's going to be liable. And again, employers are not just responsible for the income tax portion, they're responsible for CPP, EI, and there's also, as you all know, I'm sure, employer portion. So there may actually be an incentive for us to want to classify a worker as an independent contractor. CRA has the responsibility for administering all of these acts together, and if you're HR professionals, you've likely seen T4 slips with these types of withholdings on them many times in the past. So what happens in a CRA audit? So these are not typical audits generally, but I'll sort of take you through how they proceed. So independent contractor versus employee audit or review, it can be initiated for any number of reasons. Some of the reasons that I've seen and are common as well for other practitioners are a payroll trust exam. So that would be a payroll trust examiner comes to the business and reviews the payroll, just a typical audit of payroll, but we use that fancy term as the CRA. It's possible that a former disgruntled or whatever worker may have provided a tip to the CRA tip lines. That employees, independent contractors, businesses, they have the option to proactively request that the rulings directorate issue a decision. That way they're mitigating risk on the payroll withholding side. There's also a high element of random chance in this. And then on top of that, you can increase your odds if you're in one of the high risk industries. So construction is a big one. Let's see, salons, spas, trucking is another one. Any industry where there's a lot of cash changing hands, that's generally, it's not even quarantined here to payroll. If you're in a business where you're dealing in cash quite a bit, expect that the CRA is going to be knocking on your door and sending you letters more often than your peers. So what happens then is, in any of these scenarios, a referral is going to be sent to a place called the Rulings Directorate, which is in Ontario. It's in Kitchener, I believe, right now, but there's 3 or 4 of them across Canada in the various tax services office. What will happen is we'll get an initial contact. Generally, the employer will get that contact by way of written letter. They'll set up a time for an interview, and they'll ask for supporting documentation. So the payroll journal, definitely the written contract of work or employment. And in some cases, they may actually conduct a field visit to sort of observe the relationship, although that's quite rare for the Rulings Directorate to do that. And as I said, the CRA has over the last 10 years been moving towards a much more centralized model. So it's not really easy for them to do that anymore. They may ask the payroll trust examiner to do it on their behalf, although generally speaking, it's what we would call a desk audit. So what happens next then is CRA, the Rulings Directorate, is going to gather information from the payroll journal and the invoicing and all of that expenses, and they're going to attempt to and contact the workers directly without your involvement as the employer. Usually they'll get them on the phone, they'll ask a series of questions, And then what they'll do is they'll send a written questionnaire and they'll ask for that to be filled out by the employee. Once they have all of that information, then they're going to apply the factors in Weavidor, Sagaz, et al. I've found over the years when dealing with this type of audit at first instance here that the rulings directorate, you know, they're going to try their best to determine that somebody's an employee. And once that happens, they will send something called a proposal letter to the business owner, and they will say, these are the facts as we've determined them. These are the reasons why we think these workers are employees. If you have anything you'd like us to add or reconsider, please let us know. If not, a determination will be issued, and then it'll be referred back to the payroll trust examiner. Generally speaking, in that type of case, a reassessment will be issued immediately. It's a strange sort of unique part of the payroll audit process that auditors will often hand create a reassessment and hand it to you on the spot. Now, in terms of what happens then, is unlike a traditional income tax assessment, payroll is considered a trust fund. The income tax for payroll, CPP, EI, considered a trust fund. So there's no 90-day halt on collections in that scenario. Payroll trust examiners will generally refer their reassessments to the collections division immediately in this type of circumstance. If it's a relatively trivial amount, they may not, but generally speaking, when you end up in this type of scenario, you're going to be looking at a bill, decent bill anyway, shocking in most cases. So if the employee, one of the things that Tim talked about too is what happens if the employee is thought that they were an independent contractor and actually has filed their tax returns properly and paid their tax. This is a double tax problem. CRA doesn't care. Income Tax Act makes no distinction for this. The liability is absolute for the employer if they did not withhold and remit. So in the past, I've helped clients work with the employees to refile and try to get a refund. I would not advise attempting to do this on your own without the aid of both a tax and employment lawyer. There's a lot of issues involved in this, but otherwise you're dealing with a double tax issue, quite possibly. So I'll just go quickly through the dispute process. It's fairly similar to income tax and GST HST. If you disagree, then you have a 90-day period within which to file a formal notice of objection, except because we're dealing with three separate statutes, CPP and the Employment Insurance Act have no mechanism for an extension of that time period, unlike the Income Tax Act or the Excise Tax Act. So what that means is once that 90 days expired, you are finished. There is no further way that you can dispute this and force the CRA to reassess. In addition to this, interest and penalties are calculated always on these things as a percentage of the amounts owing on reassessment. And with a further wrinkle, you're going to have additional penalties and interest related to the remittances based on your remittance period, which is normally month by month, right? So if you file the objection, appeals officers are much more reasonable. I've had a lot of success in that on that side in the past. However, if you're still unsuccessful, same as any other tax dispute, you still have a right of appeal to the Tax Court of Canada. So what happens if we end up in this scenario, we've exhausted our appeal rights and we still have a bunch of unremitted payroll source deductions, et cetera? Only other real relief that we can get is something called a taxpayer relief application. It's section 223.1 of the Income Tax Act states the minister may forgive all or a portion of any interest or penalties. So that means it's a discretionary decision. The court has no power to force or no jurisdiction to force the CRA to provide that type of relief. But there is a framework for them whereby which if you're using a professional and you can fall within the stated and promised guidelines, they ought to be providing that type of relief. That having been said, it's quite a high bar. So advice, it's not something I would advise somebody to wade in on their own. And so that's about my 15 minutes there. I hope that this was practical. I tried to include some of the formal case law as well as some of my own anecdotal experience there. But after myself, we're going to have a 15-minute break, I believe. And then Nicholas will be speaking to you after the break. So thank you very much. I hope you enjoyed my opinion and breakdown of the law.
Oh, thanks, Nathaniel. So just for clarity, everyone, we'll resume at for a 15-minute break. We'll come back at 10:15. Okay. Thanks, everyone. See you then. Okay, welcome back from the break, everyone. I'd like to introduce you to my colleague, Nicholas, who will be discussing the Working for Workers Act. And Nicholas, it looks like we already have a pre-presentation question for you about addressing whether non-compete provisions of contracts prior to the enactment of the legislation will be affected. So, Nicholas, without further ado, I will leave things to you.
Great, thank you very much, Marty, for the introduction. Good morning, everyone. My name is Nicholas Frankulers. I am going to be presenting on the Working for Workers Act, or Bill 27, with a particular focus on the new changes to non-competition clauses and the right to disconnect. And with regards to the question you just mentioned, Marty, that is something that I'm going to be discussing in this presentation. So I'll just mention it when I get to that point. And if there is any further questions afterwards, we'll be available either in the Q&A session, or if you want to send a Q&A or message in the chat, I can respond that way as well. So to start with a brief overview of the Act, the Working for Workers Act was announced that it had been passed by the Ontario Legislature on November 30, 2021, and it received royal assent and came into effect on December 2nd, 2021. This bill includes many employee changes to employment legislation, including, among other things, a ban on non-compete agreements with only certain limited exceptions, requiring employers with 25 or more employees to implement a disconnect from work policy, establishing a licensing regime for recruiters and temporary help agencies, prohibiting certain regulated professions from including a Canadian experience requirement as a qualification, requiring businesses to allow washroom access for delivery workers, and implementing certain employment protections for foreign nationals. So to start with the timeline for when these changes come into effect, the majority of the changes came into effect upon the bill receiving royal assent on December 2nd, 2021. So in other words, they're in effect right now and have been for slightly over 2 months, but some of them have slightly different timing. In particular, the ban on non-compete clauses actually applies retroactively back to October 25, 2021. The disconnect from work policy requirement, employers have up until June 2nd of 2022, or of this year, to become compliant with this requirement. And the licensing regime for recruiters and temporary help agencies is coming into force on a date to be proclaimed, because the government hasn't established the licensing framework for it yet. So it's unknown currently when that's going to come into effect, but presumably will be at some point in the reasonably near future. So to start with disconnecting from work policies, subject to the Employment Standards Act, which has now been amended by Bill 27, employers with 25 or more employees will be required to develop a written policy for disconnecting from work. And the term disconnecting from work is defined in the Act to mean not engaging in work-related communications like emails or calls, and not sending or reviewing messages The general idea of it is that employees should be free from performance of work outside of normal working hours. And it's required that the policy must include the date it was prepared and when any changes were made to it, if any. As part of these new requirements, an employer must provide a copy of their written policy to each of its employees within 30 days of the policy being prepared. And if the policy is amended, the amended policy must be provided to all workers within 30 days. And when a new employee is hired, the employee has to be provided with a written disconnect from work policy within 30 days. Employers are also required to retain a copy of every written disconnect from work policy for 3 years after the policy ceased to be in effect. And as I mentioned, the employers have 6 months from when the Act came into effect. So in other words, up until June 2nd, 2022, to implement such a policy. And if they haven't implemented it by then, they will be in breach of the Act and potentially subject to financial penalties. Now, an important point to make regarding the disconnect from work policy requirements is, apart from saying that it must include the date it was prepared and when changes are made to it, the Act doesn't actually mandate any specific contents on what the policy must contain. The bill does provide that the written disconnect from work policy, quote, shall contain such information as may be prescribed, end quote, which essentially what that means is the government is leaving it open for a regulation to be passed in the future mandating specific substantive content as to what the disconnect from work policy could contain. I mean, you can imagine the government might pass rules on, what would be a reasonable policy if there's exceptions to the policy when employees still have to work outside regular working hours and answer emails. Well, what's reasonable and not reasonable in terms of exceptions. However, currently, no such regulations have been passed. So this will be something to watch to see what happens in the future, because currently, in my view, the new disconnect from work policy requirement, it doesn't really have a huge amount of teeth in the sense that, again, it hasn't been interpreted by the courts yet because it hasn't yet come into force, but it appears that employers must have a policy, but the court or the government hasn't actually passed anything specifically saying what the substantive content of the policy needs to be. But again, that's been left open by the Act for future regulations on that to be passed in the future. So that's something to keep an eye on. And we potentially may be having future presentations on that depending on how the law on this develops. So to move on to the second major issue I'm going to be talking about in my presentation is Bill 27 now bans non-competition agreements in most employment contracts. And a non-competition agreement is defined in the Act as an agreement or part of an agreement between an employer and an employee that prohibits the employee from engaging in any business, work, occupation, profession, project, or other activity that is in competition with the employer's business after the employment relationship between the employee and the employer ends. And to get into a bit more detail on that, non-competition clauses are something that many employers quite commonly throw in as a standard term in their employment contracts, often without really considering whether the clause is actually really necessary or enforceable, or if it came down to it, whether they would really actually likely seek to enforce it. And typically the kind of wording you'll see in one of these clauses is it'll provide that when an employee stops working with the employer, whether it's because they resigned or been terminated or for any other reason, there'll be a certain set period of time, it could be 3 months, 6 months, a year, 2 years, when the employee won't be permitted to work for a competitor, and the clause will hopefully define what is meant by a competitor within a specific geographic radius. So it could say 5 kilometers, 10 kilometers within the GTA, within all of Ontario. Now, a lot of employers like to put these clauses in their employment contracts, again, sometimes without really thinking about it too much, but the courts are quite, even before Bill 27 at common law, which is judge-made law, the courts have been very strict in enforcing these clauses, and most non-competes, I would say, even before Bill 27, are probably unenforceable, and the court would really only enforce them when they were really strictly necessary to protect a legitimate business interest of the employer and were clearly defined, reasonable in scope, and had a reasonable timing and geographic constraint. And essentially, if you were an employer, it is and continues to be important to have the clause drafted clearly, concisely, and as narrowly as possible, so that it's only limits the employee's competition to the extent reasonably required to protect the employer's interests. And so, just to give a simple example of a clause that would likely be found unenforceable at common law, if you have a senior employee working for your business strictly provides services in the GTA. If you have a clause that prohibits the employer or the employee from going to a competitor anywhere in Ontario, that clause is probably going to be unenforceable, because it would, in theory, prevent the employee from, say, going to a competing business in Ottawa, even though if you only do work in the GTA and the competitor only does work in Ottawa, you're not really actually competitors. There's no actual real legitimate reason. So that clause would likely be struck down as enforceable. And there's lots of different reasons clauses are struck down. It could be that the employer has said it needs to be in place for 2 years, and the court only thinks it's necessary for 1 year, or they just don't think it's necessary at all, given the nature of what the employee actually did. But that's just an example of the types of things the courts look at. So the big change with Bill 27 is that the common law continues to apply. However, in addition to the common law, certain, or essentially all, non-compete agreements in employment contracts are now unambiguously expressly prohibited, except in 2 limited exceptions. And so the first exception is when the clause relates to the sale or lease of a business. So when a small business is sold, it can be quite common for the seller or proprietor of the business to stay on as an employee to assist the purchaser with a smooth transition of the business and customer base from the seller to the purchaser. And in those contexts, Bill 27 does not prohibit a non-competition clause. And the policy rationale for that is that if someone's buying a business, they have a reasonable expectation that the person selling it is not going to, turn around and 6 months later opening up a competing business, just down the block, because part of what you're buying, well, presumably, is the goodwill and customer base of the business. The second major exception is in Bill 27 is that it does not prohibit non-compete agreements between an employer and the employer's executives. And executive is specifically defined in Bill 27, and I've put the definition in the slide. It's essentially someone who has to be, you need to be quite senior, a C-suite executive, like, for example, the CEO, CFO, and so on. Whether someone is considered to be an executive is, we anticipate, probably something that's going to be a focal point of future disputes as to whether non-compete agreements are enforceable. And just to emphasize again, that even if your non-compete agreement falls within these exceptions, meaning it relates to the sale of a business, or it is within executive, it doesn't, just because it doesn't fall afoul of Bill 27, it's not automatically enforceable. It still has to comply with the common law, meaning that it's not overly broad, it's clear, and it's necessary to protect a reasonable business interest of the employer. So if you are trying to rely on a non-compete clause in an agreement, it's important to seek legal advice to make sure the clause is properly drafted and it's likely to be enforceable. In terms of the timing and application of these new amended rules regarding non-competition clauses, these amendments to the ESA are deemed to be enforced retroactively up to or back to October 25, 2021. And there's been a couple of recent cases that appear to confirm that this is how the law is going to be applied, meaning that, in other words, if you have a pre-existing non-compete agreement that was entered into prior to October 25, 2021, that clause is not going to be impacted by Bill 27. So it may, it's not going to be automatically unenforceable, although it may, could or could not be enforceable under the common law. So if that clause is important to you, it's probably wise to consult a lawyer to have advice on it. But any clauses or any employment agreements entered into on or after October 25, 2021, they contain a non-compete agreement that doesn't comply with Bill 27 will be barred and unenforceable. And it's important to note that in addition to the clause being unenforceable, there's also a financial penalty for not complying with the act, and employers can potentially suffer penalties. So that covers that. I've now covered the two main topics I wanted to talk about: disconnect from work and the non-compete agreement ban in Bill 27, which I think are really for most people the major changes in the Act. They'll be introduced by Bill 27, but to talk briefly about a few other changes that have been implemented by Bill 27. One of them is it started the process of introducing a licensing requirement for temporary help agencies and recruiters. Essentially, it's going to require all recruiters and temporary help agencies to be licensed. It's going to be yearly license that will be non-transferable, and there's going to be a public database that lists all active, revoked, and suspended licensees. And an employer is going to be prohibited from using the services of any recruiter or help agency that isn't licensed. So this hasn't come into effect yet because the government hasn't yet set up the framework for implementing these licenses. But presumably that's going to happen at some point in the reasonably near future. So if this applies to your business, it's something definitely to keep an eye out on. To briefly talk about some of the other changes, the Bill 27 is trying to lift barriers for internationally trained professionals by removing certain Canadian experience requirements and duplicate official language proficiency testing. It's also another notable change is it's providing for a right for washroom access for couriers, truck drivers, and other delivery workers who generally will have to be provided with access to washrooms anywhere they're picking up or delivering things, with certain limited exceptions to where it wouldn't be practical or reasonable for health, safety, or other reasons. Final change, just briefly mentioned, I put it up on the slide. There's going to be new prohibition on recruiters taking fees from foreign nationals when they're reaching out to them. And the goal is to try to protect foreign workers and avoiding scams and deceitful recruiters when they're looking for work in Ontario. So I'm almost out of time. So just to do a brief overview and summary of the major changes we just talked about and what we suggest employers do is any employment agreement that's been entered into on or after October 25, 2021, you should look at it and make sure it does not contain a prohibited non-competition clause, because if it does, and one, it's not enforceable, and two, there could be a financial penalty. Something you might want to consider if you realize your employment contract does have one is send a letter to the employee advising that you don't intend to enforce the clause. If it's required, you may want to consider alternative types of restrictive covenants. So for example, the Act doesn't expressly prohibit non-solicitation clauses. So in other words, preventing an employee from expressly soliciting the customers of your business as opposed to competing as a whole, that may still be enforceable. It's not strictly barred by Bill 27. If you want to rely on the executive exemption under Bill 27, you want to make sure those job titles are clearly defined. And if you have 25 or more employees, an employer must prepare a disconnect from work policy, and employers who use recruiters and temporary help agencies should follow the law on that as it develops. And once the licensing requirements come into effect, to make sure that any recruiter or temporary help agency that they use is properly licensed by the government. So that is the end of my presentation. So thank you very much for listening. I will be around for the Q&A later, and I can also answer any questions that are submitted via the Q&A feature. And I'm going to pass it on to Marty, who has our final presentation of the day.
Well, thanks, Nicholas. Great presentation. It looks like you've already got, I see 6 questions that were posted in the Q&A. So there you have it. It looks like the participants were engaged with your presentation. So I'm going to get going here with our last presentation of the day before we do our formal Q&A period and wrap things up. So hopefully you can all see this. Let's get the slideshow going here. Okay, so this topic is about whether the level of sophistication of an employee is relevant in determining the enforceability of a termination clause. So the brief background here is that in the Employment Standards Act, there are statutory minimums that are set out for notice and severance pay. Neither an employee nor an employer can contract out of the ESA minimum requirements. So if an employer tries to include a termination provision, which results in a lesser right or benefit to the employee than what the employee would have had in the Employment Standards Act, then the clause will be unenforceable and the employee will be entitled to a longer common law period of reasonable notice. So that principle is set out in a decision called Mattinger and HOJ Industries. And more recently, employers unfortunately have to deal with a decision called Waxdale and Swagan North America, which essentially says that if any provision in the termination scheme is unenforceable, then the entire termination scheme is unenforceable. I'm not going to get into detail about the legal analysis there. If you'd like to ask me either during the Q&A period or after the presentation at some point, I'd be happy to get into it. But just for now, understand that if any portion of the termination clause is unenforceable, then the entire termination clause is unenforceable and the employer is stuck with the common law. In a decision called Rahman and Canon Design Architecture, what happened there? The court had to look at whether or not the employee's level of sophistication should be relevant in determining the enforceability. So she was a woman of experience and sophistication. She was hired into a senior role at a fairly high salary. She had legal advice. There were lawyers involved in negotiating her employment contract. And she ends up with a clause in the contract which says here that Canon Design maintains the right to terminate your employment at any time and without notice or payment in lieu thereof if you engage in conduct that constitutes just cause for summary dismissal. I'm not going to get into the analysis in detail here, but I think it's fair to say that there is a general consensus in the employment bar that this provision would have thought to have rendered the entire termination scheme unenforceable, having regard to the Waxdale decision. In any case, the employee takes the position that the termination language should be unenforceable, and she's seeking a common law notice period. And Justice Dunphy found that the termination provisions did not contravene the ESA. And I've mentioned Justice Dunphy by name, in particular, just to tell you that he does have a reputation as being a fairly pro-employer judge. So if you are an employer and you see that, that Justice Dunphy is your judge, then that is good news. So in Rahman, the judge said, yes, this was a significant plaintiff. This was a significant, a sophisticated employee. This was an employer that got legal advice. I am upholding the termination clause, and the employee is only going to receive the statutory minimums. But then just a few weeks after Rahman, in two cases, one's called Livshin and the other is called Campbell-Givons, the court applied the decision in Waxdale and basically said, nope, the just cause provisions are unenforceable, the whole thing is out. So we essentially now have conflicting decisions about this issue, because in Livshin and Campbell-Givons, the court specifically held that the sophistication of an employee is not relevant. So here are the facts in Livshin, but essentially he gets terminated without cause. He takes the position that the termination provision is unenforceable, and the employer says, well, we think it is, but even if it's not, the whole thing doesn't really matter, because as per the Rahman case, this was a sophisticated employee, and the court should just accept what clearly was the intention here. But the court says, nope, sorry, doesn't matter. It's the language that matters, not the level of sophistication. So judgment for the employee. Same idea in Campbell-Givons, employee wins, okay? And the takeaway here is basically that a termination clause cannot comply with the ESA for some employees, but violate the ESA for others. It either violates the ESA or does not, and it is either enforceable or not. So this is perhaps the key quote to take away from Campbell-Givons. And I'll read it out to you. That the court found as follows: "It is also problematic, in my opinion, to engage in a detailed analysis about the level of sophistication of an employee and whether or not they had time and opportunity to obtain legal advice. A termination clause cannot comply with the ESA for some employees, but violate the ESA for others. It either violates the ESA or does not, and it is either enforceable or not." So in other words, it's the language that matters. It's not about the level of sophistication here. So to conclude this topic briefly for you, so Rahman says that the level of sophistication of employees matters. Livshin and Campbell-Givons basically say no. So what do we do with that? I think it's fair to say that there's a general consensus in the employment bar that Rahman what was not correctly decided, in that it doesn't follow the Court of Appeal decision in Waxdale. So to be clear, the Court of Appeal is the highest court in Ontario, and the Court of Appeal's decisions are binding on lower courts, such as the Superior Court, which decided Rahman, Livshin, and Campbell-Givons. So probably going forward, Rahman should be seen as a bit of an anomaly, and likely the level of sophistication will not matter. But of course, if you are an employer, I don't think it hurts to take a position in line with Rahman and try and argue that your facts are as similar as possible to Rahman if you find yourself in this position. In order for termination clauses which limit an employee's entitlement to the ESA to be enforceable, they do really need to be drafted carefully. So we highly recommend that you speak to a lawyer in that regard. So that concludes the presentation on this topic. I'm going to stop sharing my screen here, and we are going to move right into the Q&A period. So, all right, hello everyone. Tim's back, Nathan's back, Nicholas I'm sure is around somewhere. So I think we've had a lot of questions that have already been addressed in writing by our panelists. So when Nicholas pops back, we'll check in with him on some of the there's a lot of questions that I see here about the Working for Workers Act. The last two questions I'll just answer quickly. For CPD, I believe you just report the hours. I'm not sure that any certificate is necessary, but we can certainly discuss that with you, Marty, offline. And there's also a question here, which I will address from Mizan. Would an unsophisticated employee be entitled to more? I am going to say that even though we have conflicting case law here as to whether that factor matters at all, I'm going to say that no, sophisticated, unsophisticated does not really matter. And what matters is really the Court of Appeals decision in Waxdale. And I think that, I mean, who knows what decisions will come next, but I tend to think that the Rahman decision is a bit of an anomaly, and that it really is going to depend on the language, and less so as to, you know, whether legal advice was obtained and how sophisticated the litigants were. Okay, so we have a few questions here. Oh, I see another one has come through in the chat about vaccination policies. So I guess I will just take that one. Let me just read the question and get an answer to that one. So the question says, are vaccination policies commonly including booster doses? Do employers have the discretion to require boosters? So that's a good question about boosters, and part of the trouble with boosters is that the definition of fully vaccinated based on the provincial legislation is 2 doses. It's not 3. I think in certain cases, if you had at least 1 dose that was recognized somewhere else worldwide but not in Canada, you would need 3 doses. But for the mRNA doses, you would need only 2. And the other challenge that we're facing in Ontario is that the public health recommendations from NACI, the National Committee on Immunizations, they are basically saying that if you've had COVID, you should be waiting 3 months to get a booster. And we had a lot of COVID cases very recently in January. So there's going to be a lot of people that, based on that public health advice, are not going to be able to get a booster in accordance with the advice. So what some employers have done, and I have helped with this, is to essentially have a provision in a policy to say that, you know, you're required to get a booster in accordance with public health recommendations. So I've seen that before. I've done that before. And if you have any more specific questions about that or your entity's policy, please feel free to get in touch with me. So Nicholas, are you there or having any technical difficulties? I'm not sure yet. I'm going to assume that Nicholas is having some technical difficulties here. Oh, he's also, I think, answering at least one question here. Oh, Nicholas?
Oh yeah, sorry, I'm here. I was answering some of them in the chat, but
okay.
I guess perhaps.
Well, you know what? We have a bunch of questions that pertain to your topic, and we are in the Q&A period. So did you want to maybe go through as many of the ones about your topic in the next 10 minutes and just answer them orally?
Sure, I'd be happy to do that. So there's quite a few of them specifically regarding the disconnect from work policy, and there were some specific questions. Some of them I've answered, some of them I haven't, regarding questions about who does the disconnect from work policy apply to, what does it need to contain, that type of thing. So it just generally, right now, the government hasn't really, well, so first of all, on who it applies to, the disconnect from work policy would apply to every type of employee. So it applies to regular employees as well as managers and more senior employees. Certain types of employers are actually exempt from this part of the Act as well. So for example, lawyers actually, for example, are exempt from the Act, and other professions. It's a fist pump. So yeah, so certain professions are exempt, but if you're not within one of those areas, every type of employee, whether you're a junior employee or a senior employee, the policy has to address them. Now, an important thing to note is currently the Act does not prescribe any specific content to the disconnect from work. So this is what I was mentioning, that to a certain extent, in my view, it doesn't really have a lot of teeth, in the sense that if you have 25 or more employees, you need to have a written disconnect from work policy, but the government doesn't actually say what the policy needs to contain. So for example, it appears right now, you could be free to say, employees have the right to disconnect from work outside working hours. However, they still have to answer their emails and respond to messages in these certain circumstances. And you might have a list of 5 or 10 circumstances when they still need to respond to messages. So far, the government hasn't prescribed any specific rules on whether that's going to be allowed or not. So it hasn't so much created a right to disconnect as it's just mandated that employers have a policy addressing this specific issue. And so, for example, some of the specific questions about, does this apply to managers? Does this apply to IT professionals? I guess the answer is that yes, it does, but it also, it doesn't, because the government hasn't mandated any specific requirements for the contents. You could have a carve out for, IT professionals still need to work remote, do something outside regular hours if it's urgent, or whatever the case may be. The employer currently has the discretion to set those types of exceptions in the clause. This may be changed in the future. The government has set the act up so that they can, by regulation, they can prescribe certain contents, but so far they haven't done that. So again, currently there's nothing specific the policy has to contain, but this will be something to watch, because based on how the policy or how the act is worded, it's reasonable to think that at some point in the future, the government is probably going to pass some regulations saying the policy must contain this, must contain that, can't contain this, can't contain that. But just so far that doesn't exist yet. This is quite a new thing, so we'll have to watch and see how it progresses. And I think that essentially gives an answer to most of the questions regarding the right to disconnect, or the disconnect from work policy. There was a specific question: do you have to specifically give it to your employees, or can you just post it on the company intranet? I would say it's not really 100% clear based on the act. It's currently worded. I think in the interest of being cautious, it's probably advisable to both post it on the internet and specifically draw it to the attention of employees, whether it's handing them a physical copy or sending them an email to their company email saying, here's a copy of the policy. But again, that's not specifically set out in the act, but in the interest of being cautious, that's what I would personally recommend.
Okay, Nicholas, were there any other questions that you wanted to address? There was one that came in just a minute ago. It says the legislation on disconnect seemed to be rushed and more about electioneering politics than prescribing rules beneficial to employees. If regulations come out, do you expect them before the June 2nd deadline? So did you want to weigh in on that one?
Sure. Well, I mean, I think it's difficult to, it's difficult to say whether the government is going to pass any sort of specific regulation on that before June 2nd. I mean, currently they haven't, but and I'm not specifically aware of anything coming down the pipeline. But I mean, that's still a few months away, so it remains to be seen. So I do think it would be advisable for employers to watch out for that. I mean, it's kind of a hot button topic. So I mean, we'll see if the government does pass some specific requirements that could be something that makes the news. But I would suggest that employers do. I'm not sure, Marty, do you have any thoughts on it? But I mean, at this point, we can't really say whether that's likely to happen or not. And I would kind of generally agree that there's it's more so the policies, the current rule is more so about, I think, form than actual substance, because again, you have to have a written policy, but it doesn't really say what the policy specifically has to contain. So whether that gets further defined before June 2nd or not, I think we'll just have to wait and find out.
Yeah, I mean, the other issue is going to be with enforcement. It's really not all that clear about how this is exactly going to be enforced. But one other thing I would like to say about the right to disconnect specifically is there already are provisions in the Employment Standards Act that address issues like limits on hours of work and break times and things. Now, there are a whole whack load of exemptions to different kinds of employees as well. But when you have limits on hours of work, for example, so you can't, well, for example, I mean, after 44 hours a week, that's when overtime kicks in, and if you really want your employees to work more than that, you start getting into averaging agreements, under the Employment Standards Act. Well, they're not calling that a right to disconnect, but if the employee can only work a certain number of hours, essentially that objective could be achieved, at least in part, elsewhere in the ESA. But this is very new legislation, and we do have to watch closely, I think, for any regulations that are going to come in. And there really has not been a whole lot of guidance, as Nicholas has pointed out, in terms of what actually has to be in the policy. It's more just a matter of having a policy. I see another question here in the chat about whether or not employees have to sign to acknowledge. I'm not aware that there's any requirement in the legislation about signing it. I think, as Nicholas addressed already, it's more a matter of drafting the policy and making sure it's brought to the employee's attention. And like any policy, it should be reviewed regularly. Probably have time for a couple of more questions here. I think we've answered a lot of them. I acknowledge the one here about here, if there are two separate subsidiaries under the same umbrella, would the number of employees be cumulative or independent in terms of the number of 25 employees? Nicholas, I'll pass that one on to you, although I would just note that if it's effectively the same company or people controlling the entities, we're going to start getting into common employer stuff. But Nicholas, I'll invite you to comment on that one as well.
Yeah, I mean, Marty, I think I agree with you. I mean, it sort of depends on the specific context. The Employment Standards Act and employment law generally does have certain rules that if sometimes companies have different corporate entities for various reasons, but in the various liability or tax or other reasons, but in the employment context, if they're all, if all these entities are essentially acting as a single common employer and carrying on, same common business, they can all be considered, that sort of separate corporate entity can sort of be disregarded for employment purposes, and they're all considered the same employer for purposes relating to the act. So I think it would depend on a case by case basis, but I think certainly in circumstances, you have two separate corporations and you have 15 employees working for one corporation and 15 for the other, but essentially they are carrying on the same business. I think probably it would probably be wise to have the written disconnect from work policy, even if it's maybe ambiguous whether it actually applies or not. If you have 15 for one, 15 for the other, if they're really common business, I think you would want to, just to be on the safe side. But again, that's just, we'll have to see how it gets interpreted by the courts. But that's sort of, in the interest of being cautious, that would be what I recommend.
All right, so thank you, Nicholas. So in the interest of time here, I'm going to quickly answer. It looks like we're getting a lot of questions, so thank you all for sticking around during the Q&A period, first of all, and for your questions. I'm going to quickly answer a couple more, and then I'm going to wrap things up. And if we have not gotten to your question or you have follow-up questions, please do feel free to get in touch with us at some point after the seminar. So just quickly here, there's a question that I see that says about the right to disconnect policy. The question is whether it has to be provided to employees by March and then only takes effect in June. I would say my understanding is that because this legislation is new, it's basically a June deadline for this year, but afterwards it's going to be, I believe, 3 months. I think is the time period going forward, but June is for 2022. Is that Nicholas? Is that your understanding of it?
Yeah, well? my understanding is that this year the policy has to be in place by June, but in following years, if you have 25 workers as of January 1, then by March you have to have the written policy in place.
Right. So it's March and subsequent years, June this year. And then I'm just going to answer that. We got a couple of COVID vaccination policy related questions, which I probably can't do justice in a sentence or two here. But I'll just comment quickly that there is one question that came in. The question is, well, can an employer implement a vaccination policy which requires employees who are working from home to get vaccinated? And just briefly, I would say no. If you've got an employee who is working from home exclusively and is not required to come into the office, then I would say that very likely it would be unreasonable for that policy to apply to that particular worker. So on that note, I wanted to thank everyone again for attending this morning and for engaging with our presentations and for asking some great questions. The slides are available. I did post the link in the chat here. It's devrylaw.ca/presentations. So if you go there, it should be the most recent edition there. So not only can you see the slides from today, but you can also see the slides from our past employment law seminars and other presentations as well. If you have any other questions that you just thought of now, or any follow-up questions to anything that was said today, feel free to get in touch with any of us by phone or by email. I do want to remind everyone listening today that Devry Smith Frank is a full service firm. We have over 70 lawyers. We have offices in Toronto, Barrie, and Whitby. So we obviously practice in employment law as you've seen from today, but we are a full service firm. So if you name it, we probably do it. So feel free to get in touch with any of us about any legal needs that you or your organization may have, and we can certainly get you in touch with the right lawyer if it is not us. We typically do these seminars every few months. The next seminar will likely be in May or June. So feel free to join and watch for information about that. If you do not get emails from our firm and would like to, feel free to sign up for our mailing list. And finally, the accreditation, I know many of you are excited about that. So again, a reminder, lawyers, 2 hours of substantive content, CPD, human resources professionals, same thing with the HRPA. Although once again, I am told that link or that code, I think it's a letter and numerical code, that is supposed to be emailed to you tomorrow. So if you don't get it by tomorrow, feel free to get in touch with us about that. Okay, so that concludes the presentation for today. Thanks very much, everyone, and have a great day. Take care, everyone.